Welcome everyone to tonight's session on our legal rights at the workplace. Our host Safa will introduce herself in a minute, but for now I'm going to talk about myself. I am Steph. I'm the programs manager for employability and upskilling and the arts and heritage projects at Blossom LGBT. I use the he/him pronouns. For now, I would like to thank everyone for joining us and well, last time I said I hope you've been enjoying the gorgeous sunshine, but tonight I cannot say the same because it's been cloudy and rainy and cold. But hey, some more sunshine coming through. So, throughout tonight's session, I would like to encourage everybody to ask us questions, send us comments, feedbacks. It's always very, very welcome. And you can remain anonymous as usual. You will see the QR code at the bottom of the screen. You can scan it, it will take you to an anonymous form that you can fill out, and then I will be reading your questions and sending them through to Safa. I would just like to send a gentle reminder to everyone that we do not tolerate any form of abuse or discrimination towards us, our hosts, our attendees, anyone attending, or participants, or anyone else. The space is for all of us to learn and engage respectfully. For now, I'm going to give the floor to Safa. Please introduce yourself, and I will be in the background.
Thank you, Steph. Thank you. And good afternoon, everyone. Thank you for being here today. I know we're all a little bit tired of Zoom and online meetings, so I appreciate everyone joining us today. Today's session is going to be about your rights in the workplace as LGBTQ individuals or even as allies. My goal today is to arm you with the knowledge you need to feel sort of safe and confident and empowered in the workplace. We'll be talking about what laws there are in place to protect you and what you can do if things go wrong. So a little bit about myself. I studied and practiced law for a couple of years. I worked primarily in contract law, but I did some work in housing and employment law before eventually sort of moving out of the legal space, or out of at least the sort of representative legal space, into more corporate law, which is what I do now. I work in the corporate risk space, making sure that the companies I work for are doing their best to represent their clients, and that they're not breaking the law accidentally or intentionally when it comes to things like managing pension funds and any other assets that the organization manages. So yeah, that's kind of a brief background on what I do. But for today, what we'll be talking about is LGBTQ discrimination. I think everyone attending the seminar already knows, but it's worth repeating. Discrimination against LGBTQ people can be detrimental to mental health. It can be detrimental to productivity, to the workplace culture. An inclusive workplace environment doesn't just benefit queer employees, it kind of makes the whole place more cohesive. There's a lot of people that think these issues are kind of behind us, but if you've been watching the news, if you know anything about sort of how our culture is regressing, you'll know that actually it's still a real present issue. More than a third of queer people say that they feel the need to hide at work out of fear of discrimination. People who are out at work, 1 in 5 of them say they experienced negative comments or conduct from their colleagues because of their queer identity. And if you're a trans person, there's basically like a 12% chance that you have been physically assaulted by either a colleague or a customer, according to surveys that were done last year. So this is still really a continuous issue that we need to deal with. But discrimination against LGBTQ people is not just unfair, it's actually illegal. So whether you are part of the community or you're an ally, knowing your rights will help us create a safer space for everyone. So today we'll be focusing mainly on sort of sexual orientation and gender identity in the workplace, but it's just important to stress that real life scenarios often involve multiple forms of discrimination. We all walk around with many identities, race, gender, class, disability, and discrimination often doesn't just sort of pick one. They overlap in ways that make life harder for everyone. Queer issues don't exist in a vacuum. So queer issues aren't just about your right to exist as a queer person. It can also be your right to housing, your right to employment, your right to education, your right to healthcare. So these are all things that we need to take into account when we're talking about queer rights. Immigration is another big area. We saw in 2022 the introduction of the Nationalities and the Borders Act, which imposes even stricter requirements on LGBTQ asylum seekers, essentially making them go through all of these like evidentiary requirements that are really hard to meet. They need to do credibility assessment. They need to show documentation. They need to have character witnesses, making it really difficult for people to prove their queer identity. We've seen cases where judges have rejected claims based on these sort of increased evidentiary claims. Housing is another big issue where queer rights intersect with sort of general public rights. So in the housing space, we've seen cases where couples were denied joint tenancy agreements because they were queer. We have seen cases where local councils and housing authorities have failed to protect tenants from discrimination from their neighbors, which is just really awful to think about. But as I said, today we'll be focusing on sexual orientation, gender identity, and your protections specifically in the workplace. But it's just good to know that these are part of wider issues that affect us, and that we can sort of apply maybe some of the same principles to those other areas. But for today, we'll mainly be focusing on your rights as a queer person in the workplace. So before we get started, I'm just gonna present two scenarios. You don't have to comment yet, just have a think about them. And at the end of the presentation, we'll revisit them and see if what you initially thought and if you have had a change of mind. So the first scenario is Jordan, who is a straight man, but is perceived to be gay by his colleagues because he dresses really well. As a result, he is excluded from team activities, he is dismissed in meetings, he's not being taken seriously. Do you think this would be considered discrimination? The second scenario is Alex. So Alex was overlooked for a promotion at work because his employer found out that his partner Jamie is going through gender reassignment surgery. Alex's work has been exemplary, but his manager believes that his partner going through gender affirming surgery is going to be distracting for Alex. So they kind of overlooked him for the promotion. These are just two scenarios to get us thinking. We'll come back to them at the end and revisit your thoughts. And the last thing I'll talk about before we move on to actually discuss the legislation is this concept of vicarious liability. Because we are discussing sort of discrimination in the workplace, this concept is really important. So employees can be held liable for discrimination even if they didn't personally endorse it or weren't even aware of it. A key factor is if you are an employee and you have experienced discrimination in the course of your employment, then your employer is responsible. They are responsible unless they can show that they have taken reasonable steps to prevent this discrimination. Now, reasonable steps doesn't just mean, you did a training 3 years ago on how to be nice to everyone, or there's like a policy somewhere that says there'll be discriminatory towards gay people. They need to show that they have actually taken reasonable steps into making sure that your workplace is safe for you to be in. So this is something that's really important because often employees will say, well, it's not me, it's some other employee, but actually if there's something that's happening during the course of your employment, they can be held liable. So on to the actual legislation. So the Equality Act is the star of the show. The Equality Act is the holy grail of UK anti-discrimination law. It protects people against unfair treatment based on 9 different protected characteristics, which includes sexual orientation and gender reassignment. The great thing about the Equality Act is that it doesn't just apply to if you are already employed. It also applies to freelancers, it applies to contractors, it applies to even if you're just like applying for the job and you haven't even got it yet, but you experience some discrimination, the Equality Act will protect you. So The other great thing about the Equality Act is that what it did is previously we had lots of different protections under lots of different acts. So we had the Sex Discrimination Act of 1975, Race Relation Act, Disability Discrimination Act, and all of them in 2010 were codified under one large umbrella of the Equality Act. So a lot of the protections we'll be discussing today are highlighted within the Equality Act. It's kind of the main source that we'll be referring to. The Equality Act applies to public bodies mainly, but it can also apply to private bodies if they have some sort of public interest. So if you work for a private company, but they have a contract with the government or they provide some sort of public service, they will be covered under the Equality Act. So that's just something to keep in mind. There are four main different types of discriminations or unlawful acts that are highlighted within the Equality Act: direct discrimination, indirect discrimination, harassment, and victimization. We'll talk about each one of these in a little bit. So the 9 protected characteristics under the Equality Act. First, we have age. So this protects people against discrimination based on their age, regardless of whether they're really old or really young. Disability. So there are protections for disabled people, and that can include physical disabilities or mental impairments, any kind of substantial long-term adverse effects that it has on your life will be considered under the discrimination against disabilities section. Another protected characteristic is gender reassignment. So this protects individuals who are in the process or have completed gender reassignment. As of a few years ago, there was a landmark case of Jaguar Land Rover, I think it was called, where it was decided that gender fluidity and non-binary people are actually included within the gender reassignment category. So they are also protected within the Equality Act under gender reassignment. Other protected characteristics include things like marriage and civil partnerships. So you can't be discriminated against based on your marital status or your civil partnership. Pregnancy and maternity, race. We also have religious belief or philosophical belief. This one can be a little bit complicated. Religious belief can include any of the major religions, and it can also include no religion. Anything that you have a clear structural belief system can be considered a religious belief and will therefore be protected under this act. Philosophical beliefs are also protected under this umbrella. What is a philosophical belief has been debated in courts for years, but essentially it has to be something that is genuinely held, it has to be cogent, it has to be serious, and the court has to decide that this is a belief that is worth protecting in a democratic society. That is the test for philosophical belief. Later on, we might discuss some cases where this has been contested. So I think the last two to mention are sex, so discrimination based on gender, and finally, sexual orientation. So this protects individuals from discrimination based on their sexual orientation, including heterosexuality, homosexuality, bisexuality, you name it. So these are the 9 protected characteristics under the Equality Act. So if you experience discrimination, harassment, or victimization for any of these characteristics, you have a claim under the legislation. So we can discussing a little bit what these different terms mean. So direct discrimination. Direct discrimination is a really simple one. Direct discrimination is if you are treated worse than someone else because of your protected characteristic. That's it. That is unlawful. So if you have experienced less favorable treatment compared to someone who doesn't have that protected characteristic, this is called direct discrimination, and this is illegal under the Act. There is no defense for direct discrimination. It's pretty clear cut. We don't tend to see this a lot in practice. Most cases that come through are not direct discrimination just because it's so obvious that most employees and employers have sort of put things in place to stop it. So direct discrimination is, it's not something that we see in practice a lot. Indirect discrimination is slightly more sneaky. So let's say a company has a policy that everyone has to wear gendered uniforms. This on the surface might appear neutral, but then it can end up affecting trans or non-binary employees or just queer employees in general, more so than it does non-queer employees. So if it disadvantages people who have a protected characteristic and it is not objectively justified, that becomes unlawful. So we can take a step back. Indirect discrimination requires a few different things. So number one, usually there is a neutral policy or practice. So there is a policy or practice that applies equally to everyone on the surface. But if you actually peel it back, it disadvantages some people more than others, and it disadvantages them based on their protected characteristic. So in the example we gave, the policy applies to everyone. Everyone has to wear gendered uniforms, but people who have different gendering identities or just don't fit into mainstream sort of gendered norms might experience a disadvantage based on that characteristic. Now, in some cases, actually, unfortunately, in a lot of cases, companies are allowed to practice indirect discrimination as long as they have a proportionate means of achieving a legitimate aim. So, a company, you can sort of bring a case up and say, I am being indirectly discriminated against because I'm being made to wear gendered clothes and this affects me more than it affects others. What they can say is, making you wear specific gendered clothes is a proportionate means of achieving a legitimate aim. Now, what is considered a legitimate aim can really vary from case to case, but they can cite things like operational efficiency, business needs, economic factors, cost-saving measures. It can really vary, but there are a lot of things that are covered within legitimate aim. But what they do have to show is that this specific policy is the least discriminatory thing that they can apply, that there isn't a less harmful way of achieving that legitimate business aim. So it is a little bit of a balancing act, but the sort of the legal defense is quite wide and does cover a lot of scenarios. This can also be things like if you need a specific height requirement for a job, they can say, well, we need this height requirement because we operate this machinery and this is how tall you need to be. Again, this is something on the surface doesn't apply to everyone or applies to everyone equally, but actually in reality might affect women more than it affects men. So it ends up being indirectly discriminatory. But again, it ends up being allowed under this thing of proportionate means of achieving a legitimate aim. So that's indirect discrimination. The next section is harassment. So harassment is when you feel degraded, humiliated, or unsafe at work because of who you are or because who people think you are. So harassment can include anything like sort of bad jokes, persistent misgendering, questions about your sexual identity, your sexual life. It's not really about like the intention behind the comment. It's about how the comment makes someone feel, how it creates an environment that can be intimidating or hostile or humiliating for an individual based on a protected characteristic. So again, harassment is sort of really broad and can cover a lot of things. For something to be harassment, you need it to be unwanted conduct. You need it to be related to a protected characteristic. And it has to have either the purpose or the effect of violating someone's dignity or creating an intimidating, degrading, or offensive hostile environment for someone. Again, intention is not really the important part here. It's more about the effect that it has. What is considered unwanted conduct also has to sort of go through a reasonable assessment. So it can't be, something that is to you subjectively unwanted, but to the average person would not be unwanted conduct. If someone's asking you about your weekend or, what you and your partner got up to, that cannot be on its own unwanted conduct, even if you feel a little bit attacked by that. If it becomes persistent, if the questions become more directed, if there is sort of malicious background or context, if this person has harassed you before. So all of these things will be taken into consideration. But yeah, the unwanted conduct has to be sort of unwanted for an objective person would also consider it to be unwanted conduct. So that is harassment. And the last one that we have under the Equalities Act is victimization. Victimization happens when someone is treated badly because they have complained about discrimination or supported someone else who did. So if you have filed a complaint and then, HR said, well, we'll take this complaint really seriously. Thank you for filing it. And then nothing happens. And then suddenly you're kind of getting excluded from meetings. You are not being asked to do projects. You are being sidelined. That can be victimization. So victimization, the legal definition of it is an employee or worker is subject to detriment because they have done a protected act or because the employer believes they have done a protected act. So what is a protected act? A protected act can be lots of different things. For our purposes, it's primarily bringing proceedings under the Equality Act. So if you bring a claim of discrimination directly or indirectly, if you bring a harassment claim, or you support a harassment claim or a discrimination claim, then you have done a protected act, and therefore you can't experience victimization or detriment because of that. Other protected acts include giving evidence. So if your company is being sued and you give evidence against them, or if you whistleblow on a policy or something that's happening that's not quite right, all of these things are protected acts, and you shouldn't experience detriment or pushback because of them. And the victimization section of the Equalities Act is there to make sure that you don't. Okay, so I realize I've been talking for about 20 minutes about definitions of different words within the Equality Act. So let's just change it up a little bit and do some scenarios. So I'll read, I think it's about 4 scenarios. And for each one, if you can put in the comments if you think this is something that is prohibited under the Equalities Act, and if so, under which category do you think it will be prohibited? So the first scenario is there is a company and the company introduces a new policy which requires all employees to be on the shop floor on Friday afternoon. So the policy applies to everyone, but there are employees who observe religious practices on Friday, and they are kind of being affected by this policy. So do you think, based on what we have discussed, that this is something that would be prohibited under the Equalities Act? And if so, under which category do you think it will be prohibited? So that is scenario number 1. A policy is being introduced. Everyone has to be on the shop floor on Friday afternoons, regardless of their religion or what practices they have. They've got to be on the shop floor. Do you think this is discrimination, harassment? Okay. The second scenario, I'll go through the 4 and then we can go back and discuss each one. Aslan is a gay employee at said company. He raises an issue and he says, okay, I've got to be on the shop floor in the afternoon. That's fine. If there is a little bit of a quiet day, if there's a little bit of a gap, can I take a short break to pray? This issue gets rejected. They say, no, you can't. And not only that, but his employees then kind of start making derogatory remarks towards him. I realized I haven't changed the slide. There you go, that's none. His colleagues start making derogatory remarks around him, kind of around why he bothers to pray, given that his sexual orientation. Is this something that would be covered under the Equality Act? What do we think these remarks amount to? So that is the second scenario. I'll leave it on screen for a second. Okay. Third and second to last scenario, we've got Lee, who is another queer employee at this workplace. They love hiring queer people and then not treating them so well. Maybe spoiler, maybe not. So Lee supported Aslan in raising concerns about his treatment. After this, Lee felt like he was being excluded from projects and team meetings. he had a performance review and he felt like it was maybe unfairly critical. Is this going to be covered under the Equality Act? And if so, is it Lee that's experiencing a discriminatory act? Is it Aslan? Is it both? What are they each experiencing? So Lee's feeling some retaliation for his support. What do we think? Okay, and lastly, we have Aslan finally says, absolutely not. I don't want to work here anymore. This is not a great place. I've always dreamt of being a skydiver, so I'm going to go and become a skydiving instructor. Unfortunately for him, his bad luck continues and he is penalized at his new workplace because in a casual conversation, he mentions to one of the customers that, oh yeah, me and my husband this, and the customer was very outraged and complained to the manager. The employee then spoke to Aslan and said, I'm going to penalize you. You shouldn't be talking about your personal life at work. This is not my opinion. This is what the customer has said. And we have, we try to make our customers feel really comfortable. And that is why I'm penalizing you. So under this scenario, do we think that Aslan has a claim? Under which category does he have a claim? If he does. Okay. I will give you a few seconds, maybe a minute or so, to have a think about these 4 scenarios. And we can take it from the top.
Safa, we do have some answers coming in anonymously, actually, because a lot of people don't want to.
Yeah, that's absolutely
be seen, and it's absolutely fine. This is why we have this form. So, well, we have a question as well. I'm going to post it for later. Someone said they are both cases of discrimination. I think they were talking about the first ones, maybe from before. This was from before the scenarios from the first one you said earlier. In summary, there's yes for the first scenario, it would prevent people based on religious discrimination.
Yeah, okay.
The first one. The second one, sexual and religious discrimination. I'm quickly summarizing. And yes, it is discrimination for both Aslan and Lee, and I think sexual orientation or something about freedom of expression.
Okay, yeah.
For the fourth one.
Okay. Interesting. All right, we'll go through them and it'll be interesting to see if any of these surprise you. So the first one is a company has introduced a new policy which requires all their employees to be on the shop floor on Friday afternoons. This is a policy that applies to everyone, but some employees have religious practices on Friday afternoons. And the question is this practice, is this policy discriminatory? So this policy would, in fact, fall under indirect discrimination because we have what is on the surface a neutral policy that applies to everyone, but actually ends up discriminating against some people more than others based on a protected characteristic. In this case, the protected characteristic is religious belief. So this is not a one that is based on sort of gender identity or sexual orientation. So is this company then liable? As we discussed, kind of no. The company can say and will say in cases that have come up that are similar to this, that they need people on the shop floor at a specific time for legitimate business reasons, and that there is no other way of conducting business if they allow people to not be on the shop floor at this specific time. So this case is a case of indirect discrimination, absolutely, but it is also a case where the company has a legitimate business defense and therefore will not be liable for any damages under indirect discrimination. So yeah, with this one, no money, no no recourse in this case, unfortunately. Second case, a little bit more complicated. We have Aslan, who is gay and Muslim, presumably, or has religious practices on Friday. He asks to take short breaks within whenever the shop floor is slightly empty so that he can go pray. He then, as a result, that request is refused, and his colleagues are kind of making snide little comments at him. So what we have here is, I think, two different types of discrimination. We have still indirect discrimination. There is the policy on the shop floor that people have to be there. It's an indirectly discriminatory policy. In the previous slide, we saw that they had the defense of a legitimate business reason. Here, I think that defense is slightly weakened because the request that is being made here is, when the floor is not busy, can I go pray? Can I go take a little break to practice a religious belief? If they say no, in this case, it will be a much harder example of, they'll have a harder time explaining why this is a legitimate business case, why they have to not allow him to take a break. So under this case, if he has a much better chance of claiming under indirect discrimination because their defense is weakened. But what we also have here is a different type of discrimination against Aslan by his colleagues. So his colleagues are making derogatory remarks, questioning why he even bothers to, as a joke, why he even bothers to practice religion so strictly when he's already gay. Does it make sense to do that? So that, I think, qualifies under harassment. So he is being harassed. There is unwanted conduct. That unwanted conduct has the effect of making him feel humiliated, making him feel like this is a hostile work environment. So under this case, I think this would be harassment. Harassment under the protected characteristic of sexual orientation. So we have a little bit of interplay between different types of protected characteristics. Our poor boy Aslan is really going through it today. So we go on to Lee. Let's spread the misery around. Lee, sees what Aslan's going through, says, guys, I don't think this is correct, and supports Aslan in his claim of indirect discrimination and harassment. As a result, he is excluded from meetings. He experiences detriment. So this would be a case of victimization. So victimization, remember, occurs when someone is treated unfairly because they have complained about discrimination or supported someone who has. So Lee is not being discriminated against because of a protected characteristic. Lee is being discriminated against because he has conducted a protected act, and that protected act is supporting a claim under the Equalities Act. So if he can demonstrate that the exclusion and unfair treatment were due to the support of his colleague, then the company would be liable for victimization. And then lastly, we have Aslan, who continues to have the worst luck of all time in his job, where he decides to go have fun, become a skydiving instructor, and is then reprimanded for talking about his personal life with his customers. So in this case, even though the company is saying, well, actually, no, this is not our discriminatory policy. We are just protecting our customers. This is something that our customers have complained about, and therefore we need to sort of make sure that we address it. This is actually one of the rare cases of direct discrimination. Simply put, he is being treated less favorably because of a protected characteristic, in this case, sexual orientation. If he was straight and he had talked about, me and my wife did this over the weekend, and the customer presumably doesn't have offense about that, then he would not have been reprimanded. He would not have been penalized in the same way. And therefore, this is a case of direct discrimination. This is actually based on a real life scenario in the US. Donald Zarda, I believe was his name. He was a skydiving instructor who was fired after revealing his sexual orientation to a customer. And the US Supreme Court at the time ruled that this was discrimination based on sexual orientation. And this is in violation of the Civil Rights Act in the US. And therefore, he was awarded compensation. So these are the 4 scenarios. Before I move on from these, is there any confusion about the 4 different categories that come in under the Equalities Act? I'm seeing a question here about why should we distinguish between direct and indirect discrimination? That's a really good question. So direct discrimination, as we say, is sort of straightforward, being treated less favorably because of a protected characteristic. That is never okay under the law. There are no legal defenses for it under the law. Indirect discrimination, however, might have the same effect. You are still being discriminated against. The difference, legally speaking, is that there is a defense for indirect discrimination. So companies can say, if you are being indirectly discriminated against, that there is a legitimate business case or there's a legitimate business interest. There is no legitimate business interest defense for direct discrimination. So taking this example, the company can come back and say, well, if we lose customers because they're all complaining, because Aslan keeps talking about his husband and they don't like that, we can lose customers, and therefore discriminating against him is a legitimate business case because we are protecting, the financial situation of the company. We are protecting our customers. We are retaining customers. We have a legitimate business case. Because it's direct discrimination, because the policy on its face does not treat everyone equally, that defense will not work. So that's kind of the main difference between direct and indirect discrimination, and why we separate between the two of them. So I'm seeing another question around nationality and how has the Nationalities and Borders Act been used to discriminate against queer people in recent times? That is a good question. It is a depressing question, but it is a good question. So let's go briefly back to the Equalities Act. Was it under the Equalities Act? No, I'm not sure what slide it was in, but we could just address it. So we talked a little bit about the Nationality and Borders Act in 2022. The Act imposed much stricter evidentiary requirements for LGBTQ people. So what we've seen is, in many cases, the judges have implemented something called a 2-stage assessment. So it requires the applicant to go through an initial assessment where they have to prove on the balance of probabilities that they have a protected characteristic. So in this case, it would be either a gender identity or sexual orientation, and that they fear that this identity can cause them harm or can cause them prosecution. So once they've done that, which is already quite difficult, they then have to go through a second test, in which they have to demonstrate a reasonable degree of likelihood that they will face prosecution due to this characteristic. So it goes from being on the balance of probabilities, I have this identity and I will experience prosecution, to then the second assessment, which is, it is to a reasonable degree of likelihood. So that's a much higher sort of like bar to pass, that you will, on a reasonably degree of likelihood, face prosecution for this characteristic. So the kind of things that you could be expected to do is do a credibility assessment. We have seen judges ask for, reject claims based on, well, either look that gay, or no one in your life knows that you are gay, you have not made any public statements that prove that you are gay. All of these things in context are obviously a little bit ridiculous, because if you fear prosecution, you will not be making public statements. You will not necessarily be telling people in your life. So there's a little bit of a disconnect between the level of danger that you have to prove that you are in, and then the behavior that you are required to show that you have outwardly been comfortable with your identity, or that you have outwardly expressed your identity, or you have some way of evidencing your identity, and at the same time prove that it's really dangerous for you to do so. So that disconnect makes it really difficult for people to pass these two assessments. And unfortunately, because of that, a lot of claimants cannot meet these increased evidentiary requirements, and their claims get rejected. I met someone a few months ago at a queer migrants workshop, where her and her partner had been together for something like 34 years. She managed to come to the UK a few years ago under completely different circumstances. And then when they applied for her partners to come here, the court basically said, you don't live together, you are not legally married, even though the country that she comes from, you cannot get legally married. You have not, people in your life don't know that you're together. We don't have enough evidence that this is your partner. Despite the fact that they had been together for many, many, many years. And because they couldn't prove that claim, her partner was not allowed to come to the UK and remains in her home country. So we've really seen the weaponization of this legislation against queer identity, unfortunately. Okay, so there's lots of different things we can talk about. We've covered the basics of what are the protected characteristics, and we've covered the basics of what are the categories of claims that you can bring under the Equalities Act. We can talk about housing, we can talk about immigration, we can talk about so many different things. But because we are limited for time, I chose sort of two topics that I think might be of particular interest. They're kind of hot topics at the moment. So the first one is freedom of speech and privacy. So here I want to talk a little bit about what you can say in the workplace without fear of retaliation, what speech is allowed, what speech you can get fired for, what speech you absolutely cannot get fired for. So as in many areas of the law, this is a developing area. And it's kind of a balancing act between what your private beliefs are and what is considered professional conduct. So under the Human Rights Act, Article 10, you have a right of free speech. You are allowed to say what you think and you cannot get fired for it, unless that right or unless that expression conflicts with other fundamental rights. So if your freedom of speech fundamentally conflicts with other human rights under the Human Rights Act, then it can infringe on your Article 10 rights of free speech. It is kind of a balancing act between those two things. So what kind of speech can you get fired for? Hate speech, so using any threatening, abusive, even insulting language in some cases can be enough to classify as hate speech, and you can get fired for that. Defamatory statements, so making any false claims that damage someone's reputation, that's definitely can be a fireable offense under the law. Discriminatory remarks, so comments that are sexist, racist, homophobic, or just in any way discriminatory, that speech is definitely not protected. And the two other types of speeches that are not protected are speech which is in breach of the company's policy, or speech which includes revealing or disclosing of confidential information. So those two are not covered under your freedom of speech, and you can be penalized for breaching them. So just to reiterate, speech that you can get fired for: hate speech, defamatory speech, discriminatory remarks, breach of the company policy, or revealing or disclosing of confidential information. These are all things that are not protected under your Article 10 rights of freedom of speech. Things that you cannot reasonably be fired for is an expression of your opinion, if that opinion or belief is shared in a respectful, non-discriminatory manner. Whistleblowing, so if you reveal something about your company that they don't want you to reveal, but it's an illegal activity, you're not allowed to be fired for that. Union activities, so participating in a union activity, discussing union activities, discussing workplace conditions. These are absolutely protected under your freedom of speech, and you cannot get fired for it. And then lastly, and the one that is relevant to what we're talking about today, is protected characteristics. So expressing aspects of one person's identity, specifically an identity that relates to a protected characteristic, like discussing someone's religion or discussing someone's sexual orientation. As long as these are being discussed in a non-offensive manner, these are protected speech and you cannot be fired for them. Now, of course, with a lot of these things, it will be up to the specific facts of the case as to whether something qualifies as hate speech. We've seen the category of hate speech get weaponized in different ways and used in different ways against different people. So it is complicated. It's not clear cut. And it's not always clear going in what the decision is going to be. What we have is a specific legislation that has, overarching statements or principles like hate speech is not protected, but actually breaking that down into under what circumstances is speech considered hate speech, what is considered racial incitement, what is considered religious incitement, and how you measure that up against your freedom of speech, your freedom of expression. It can be really complicated, and it's often a case-by-case decision. So there isn't really like a step-by-step guide I can give you on how to avoid or fall into these categories. But what we do have is a series of kind of like really interesting case law. I won't go through all of it, but we can discuss some just to kind of give you a view of how complicated this can be and how narrow the judgment can be. So we have the case of Christy Higgs, who was a school administrator, and she posted online sort of things related to her disapproval of gay marriage. She wasn't for it. She said that it interfered with her Christian traditional beliefs, and that as a result, she just was not for it. These statements came out, or I think she wrote about it on Facebook, and the school found the posts and dismissed her. The Court of Appeal actually ruled in her favor and said that her dismissal was discriminatory because she has a right to her beliefs, and that she essentially did not do enough harm to the reputation of the school to justify firing her. So that was a really interesting case that many people did not think would end up the way that it did. Similarly, we have another case in, I think, 2013 of Maya Foster, who was a researcher. And she, again, expressed sort of gender-critical beliefs on social media. And she was sort of fired for that because the company she worked for found that these beliefs were, or these statements were discriminatory against the people that she worked with. The Employment Tribunal initially ruled against her, but on appeal found that her beliefs were protected under the Equality Act. Now, this was a really interesting case because what it did is that it set precedent that gender-critical beliefs are protected under the Equalities Act, under that very vague philosophical belief category that we touched on earlier. So because of that case, Maya Foster, the precedent has been set that gender-critical beliefs are protected under philosophical beliefs and religious beliefs within the Equalities Act, and therefore are protected speech, and you are allowed to express gender-critical beliefs without retaliation or being fired. We have some cases that have gone the other way. We have, I think in 2013, David McGrath. He was a Christian doctor, and he refused to use a transgender patient's pronouns. He just insisted on dead naming them and misgendering them, and he was fired. The Employment Tribunal actually held that that was not discriminatory and that he should be fired for it, and that his discrimination was not discriminatory, his acts were, because that the reason that they ended up giving is that his beliefs were not compatible with human dignity and conflicted with the fundamental rights of others. So it kind of goes back to this idea of balancing what your right to free speech is with the fundamental rights of others. So in this case, because he was a doctor, because he was dealing with vulnerable patients, because he was doing sort of actual harm, as opposed to some of the other cases where we are just discussing people kind of speaking into the ether. This was directed towards people. In that case, it was decided that he can be fired for refusing to use the patient's preferred pronouns and preferred names. The last case that I can think of is Page versus NHS Trust. So Richard Page was a magistrate. He was a judge, and he expressed opinions against same-sex adoption. In that case, I think he did media interviews where he just came out against same-sex adoption. and he was dismissed. And the Employment Tribunal upheld his dismissal, stating that the comments could undermine the public confidence in the judiciary. So it wasn't just about the specific nature of the comments that he made, and it's not in general about the specific nature of the comments you make. It's also about the effect it has. Are they directed towards people? Have or can they harm the reputation of your employer? What effect it has on the fundamental rights of the people around you? And in this case, they decided that because his comments can undermine the public confidence in the judiciary, his dismissal is therefore legal. Okay, so free speech, really complicated. It's a really hot topic, and it's developing. There's lots of areas where it's still not entirely clear what your employer is or isn't allowed to do. For anyone who's involved in activism or anyone who's involved in protesting, I would just suggest to be really careful. You do, under Article 11 of the Human Rights Act, have a right for peaceful assembly, but what we have seen is sort of characterization of different protests as hate speech or incitement, and if that's the case in your workplace, then you can be fired. Whether that ends up being held or not, then it's a different question. But you don't really want to get to that point where you're taking it to the Employment Tribunal and sort of discuss, you don't want to get to that level. But yeah, expressing political opinions in a respectful and non-discriminatory manner is protected. But again, it's a very slippery slope. So just be careful. You absolutely have the right to peacefully protest. But yeah. The other thing I should quickly mention is your employers can look through your private social media and can use that to fire you or to discipline you. It's not in all cases, and in some scenarios, it's definitely been ruled that looking through employees' private social media account is stepping over the mark. You do have a reasonable right to privacy, but within certain jobs, if your job can claim, this is affecting our reputation, this is affecting our ability to generate income, it goes against the values of the company, et cetera, there are cases in which they can look through your social media and use that to discipline you or fire you. So just be extra careful. Okay, the second hot topic issue that we should cover quickly is facilities. When I started preparing this presentation a few weeks ago, I was going to tell you about, how the Equalities Act protects individuals from discrimination based on gender reassignment, which includes trans and non-binary people. And, trans individuals have the right to access facilities that correspond with their gender identity. As of April 2025, as of a few weeks ago, that is seemingly no longer the case. The UK Supreme Court ruled that the term women and sex in the Equalities Act refer to biological sex. And this ruling has really significant implication on the use of single-sex facilities in not just bathrooms, homeless shelters, abuse shelters, sports. I know the FA has released a statement for anyone who follows women's football on what that means, and excluding basically trans players from playing. So yeah, this is fresh off the press. It's still developing, but the HRC, which is the Equality and Human Rights Commission in the UK, has issued guidance following this decision that basically says, yes, in the workplace, you are now required to use the bathroom that matches with the sex assigned at birth. But they have also, in the interim guidance that they've released, said that workplaces should do their best to accommodate trans and non-binary people, and they have recommended having a sort of gender-neutral facilities as well as gendered facilities. So that's the current guidance. I don't know what's going to happen in the future. I don't know where this is heading, but it's unfortunate. Yeah. Just quickly going through what to do if you have experienced any of these things that we have discussed today. Oh, I am losing light. I'm still here. Okay, I think you can still see me. Okay, so the first thing to do is to know your rights. Familiarize yourself with the protections against discrimination, harassment, and victimization. Know what protected characteristics you have and in what ways you can protect yourself against any discrimination related to your protected characteristics. Hopefully today's session has helped you a little bit with that. Microaggressions, little comments in the workplace, things like that can add up to harassment if they are persistent, if they are severe. So, people not using the right pronouns, making little comments, these things can add up. So don't ignore it. The second thing to do is know your company's policies. So read your company's policies, read the employee handbook, see what it says about different policies on discrimination, on what the grievance procedures are, etc. Document everything. So if you think you are experiencing discrimination or harassment, make sure you record the incident, including dates, times, email. If there is any correspondence, make sure to save that. If there's anyone around you who's seen what has happened, talk with them, see if maybe in the future it can be you can use them as a witness. A lot of these claims fall apart on evidentiary basis because you can't prove what happened. So it's really important to record anything that you can record. The first step is obviously raise concerns internally. If you can't, or if you do and nothing happens, then you can seek outside claims and you can raise a formal complaint within the company. If not, then you can seek external support. If you are part of a trade union, it's really important that you get in touch with them. They are often the best place for support. They will provide you with representation. They will help speak to your employer on your behalf. Employment tribunal should really be the last possible, recourse. But if you do have to go to employment tribunal, there's a couple of different steps that you have to think about. So before you even start, they will recommend that you contact the ACAC, the ACAS, which is a government arbitration service. So this will attempt to conduct arbitration between you and your employer, come to a resolution without having to go to employment tribunal. If that does not work, you have to fill out an ET1 form. So if you just Google ET1 form, it should be on the government website. You can download it, you can fill it out and send it. You have to include within the ET1 form that you have tried the arbitration service and the specific certificate number that the arbitration service will give you that you have to include within your form. One important thing to keep in mind is that you have to submit your form generally around 3 months minus 1 day, but 3 months after the incident has taken place. There's a really strict time limitation with these things, so just keep that in mind. Your employer will receive the form, they will respond. There might be a hearing, in which case you need to prepare your evidence. At this point, hopefully you have some legal representation, and in a lot of it, I will give some contact details for different organizations that can help you, and you will attend your tribunal and hopefully get the outcome that you want. But you really don't want things to get to this point because you've just it cost you so much time and energy. If you do get to an employment tribunal, I have 1 minute, 40 seconds. There are different things that you can expect. So the different remedies that you can seek within an employment tribunal is reinstatement. So if you are fired, you can get your job back. You can get compensation, which often can break down to a basic award, which is like a calculated fixed sum for how much you have lost whilst not being in employment, and also a compensatory award for the financial losses. If you had to hire a lawyer, if you experienced loss of earning, if you've experienced any financial ramifications from that dismissal, you can get a compensatory award. There are different bands, but it can go up to like 60,000 in the most serious cases. You can get a declaration from your workplace to say, we put our hands up, we did something wrong. And finally, you can get changes. So for example, if there was a discriminatory policy, you can get them to change it. So you can implement changes in the workplace. And these are generally the kind of remedies that the Employment Tribunal can provide. So last thing is we have so many different wonderful organizations that work to support queer people, again, not just in like strictly queer issues, but when it comes to things like immigration, employment, education, houses. So I put some examples of who you can contact under different categories for support. And this one here as well, just for more general support that's not related to any specific areas, but if you're experiencing things like victimization or abuse, or if you're experiencing mental health issues and you want to discuss that with someone, there is some support available. I'll try to make this available somewhere else. Maybe Steph can help me a little bit with that. But yeah, there's a lot of really wonderful organizations that can provide you support. You don't have to go through this alone. It's a really scary process. It's a really scary time to be queer in this country and everywhere. And the best thing that we can do is just be there for each other and support each other through all of this. Okay, we are out of time. I'm not sure if we should do some questions or if we end it here. Steph, I'll take some guidance from you.
First thing I'll say is that I'll make sure that this information will be posted on our social media if relevant. If anyone wants to know about it, we can send it to them as well.
I apologize for how rushed those last 4 minutes were. I feel like
this is a lot of information. This is brilliant. I mean, we do have a lot of questions coming. We have 4 questions. I don't know if you can maybe get to each one of them in a minute or so, just to give people, maybe in a minute or so. Question. A lot of these cases come down to one said. I'm assuming that it's like, this person said. Situations and are hard to prove in that sense. I mean, if I received a certain verbal comment from a colleague, they can end up denying it or gaslighting me one way or another. Is there usually a way of proving discriminatory behavior?
Yeah, proof is something in my experience that can be really like one of the hardest bits to nail down. So in terms of what you can do to prove or to provide evidence, there's a lot of different things. You can, if things happen on email or notes or anything that's written, that's great. Save it, document it. If there's anyone around you that heard it, witness statements can be really powerful. If your workplace has cameras or videos or anything like that, being able to use it would be really good. Any digital evidence that you can get would be also really good. In terms of recording things and recording people and like saving stuff, that can be really tricky. But we've basically seen cases where, because of the context, the company the tribunal has said, there was no other way for this person to record this, and they needed to be able to evidence it. So they have allowed it in some cases, and in others they have sort of thrown it out because of consent issues. So yeah, I mean, it depends on the specific thing that is happening, but try as best as you can to record things down, to get people around you to act as witnesses. Character statements can really help. Proving a pattern can really help. If someone has said something to you, they have probably said something to other people. But yeah, looking for digital evidence, documenting things, writing things down when they happen. If you raise a complaint with HR or whoever on the day or soon after, that can also be sometimes considered evidence, even though it's he said, or whatever the gender is. Raising it at the time can often be considered evidence that something has taken place. So yeah, it's really tricky. There's no right answer, but there's a lot of different ways that you can have to think about what the best way to record things in the moment is.
Thank you. Question: how has the system dealt with hate speech or discriminatory remarks that constitute or result in harassment?
Yeah, harassment is, hate speech is just it's very complicated under the UK law. The UK law has basically places to address hate speech and harassment. There's the Equality Act. There's also the Public Order Act of 1986. They're both key pieces of legislation for hate speech and discriminatory speech. But yeah, you can, they recommend things like reporting to the police, and your employers are required to take steps to prevent harassment happening at the workplace. So in terms of legal remedy, there can be sort of changes in policies, changes in what your employer has to do to protect you from harassment. There's been some cases where there's like financial damage for emotional harm, distress, or if you've experienced financial loss, if you've had to take time off work. It can really, be those things that have been used to remedy harassment.
All right. Last question. On what basis can employers access your data, or does your data cease to be covered by data protection laws? How can you protect yourself? I'm assuming this is in relation to employers accessing your social media. And
Yeah,
yeah.
So, this was something that I was thinking about before the case. So the case that I remember most is Game Retail versus Law, in which an employer was dismissed for posting offensive things on his personal Twitter account. The employment tribunal upheld that dismissal and said that really emphasized the importance of clear social media policies and the impact of social media activities on the employee's reputation. So number one, I would check the employee policies handbook. What does it say about what they can and can't do? Because oftentimes you've signed up to these. So regardless of not regardless, but what the law says is one thing, and then what you have agreed to within your contract, within the company's policies is another. So you need to see what you've agreed to allow them to do. If your job has any kind of public facing elements or customer facing elements, that can be seen as more reason or more justification for the company to be looking at your social media. But yeah, it's really tricky. It's been decided on so many different things, and some of the examples that we've looked at, what is hate speech, what is private, is really tricky.
Okay, this was our last question. Nothing
Okay.
has come through since. And if you have any closing remarks.
No, I mean, just to emphasize what I said last, there's all these, wonderful legal protections. Some of them are here to stay. Some of them are being challenged. And there's a lot of really scary changes. And the best thing that we can do is just really be here for each other, really support each other in the workplace. I think sometimes discrimination is fostered under a certain environment. So, if we can band together to show that environment is not what we want, even if you are not queer, even if you are just not even, it benefits everyone to have a safe work environment. So I'd really encourage everyone to speak up when they can, to know what their rights are, and to not be afraid to stand up.
Thank you so much, Safa. This has been a lot of information, and very much needed in light of what's been happening, what's been going on recently as well.
Yeah.
And especially what you said now, know your rights and learn about what you can do, what you cannot do. This is one of the most difficult things that I've experienced in the UK myself, finding where I can find information, legal information, and that is, just being presented to me. So thank you so much for taking the time and doing this for us today. A big thank you as well to everyone in the audience. Thank you for your questions, your comments. This is truly valued. I'd like to ask you as well if you have any further thoughts, reflections, please reach out to us, and just let you know that your feedback really helps us shape our workshops to better serve the needs of our young queer and trans communities. So please send those across. If you'd like to stay updated with us, follow us on Instagram, YouTube, LinkedIn, Eventbrite. We've got a lot of events coming up. And you can also check our website for more information and details. And finally, if you're interested in our mentorship scheme for queer youth, whether as a mentor or a mentee, do get in touch for more information. On that note, I will ask everyone to take care and have a lovely evening. Cheers.
Thanks, everyone.